the road between the occupied city of Jerusalem and the Dead Sea, you see on the right the Palestinian villages in the Jordan Valley, reduced in size and demarcated under the pretext of having closed military zones. On the left there are Jordan's high mountains, whose beauty make you forget that there are boundaries veiled by nature's colors in the valley. On this road lies the Israeli-controlled Khan al-Ahmar. On 5 September 2018, the Israeli Supreme Court decided to evacuate and demolish the area of Khan al-Ahmar, surrounded by a number of settlements located within their territory targeted by the Israeli authorities for its E1 occupation project. The prosecutor of the International Criminal Court, Fatou bin Souda, therefore warned Israel against the demolition of Khan al-Ahmar. She added that she followed with concern the planned eviction of the population of Khan al-Ahmar, noting that the extensive destruction of property without military necessity and the forced displacement of the population in occupied territory constituted war crimes under the Rome Statute. After this warning by the prosecutor, most recently, on 5 September, the Israeli government submitted a formal request to the Israeli Supreme Court to postpone the decision on the evacuation and displacement of Khan al-Ahmar for a further 6 months, ending in March 2022, for various security and political considerations, as were stated. Under the heading Cases Under Occupation, the Perspective of International Law and the Effectiveness of Internationalization, Jerusalem and Prisoners as Case Studies, we open the first session of the conference, moderated by Dr. Ahmed Shehab, Professor of International Law and Director of the Legal Clinic in the University, Islamic University of Gaza. We are hosting both Dr. Munir, Nuseibah, and lawyer Sahar Francis. I'm giving you the floor, Dr. Ahmed, to introduce your guests and run the session. Thank you very much, Mona. Good morning, everyone. In the beginning, I welcome you all from all around the world in one of the most important activities and conferences for the solidarity with Palestinian people, which is the conference Palestine International Law, Effectiveness and Prospects, which is held on the International Day of Solidarity with the Palestinian People. I welcome also the speakers in the first session dedicated to talk about cases under occupation, the perspective of international law, and effectiveness of internationalization. As we know that internationalization, besides other international mechanisms, aim to hold international community accountable for ethically and morally and legally for not implementing the legal and international resolutions about Palestine, self-determination, return of refugees, and all other unresolved issues. And also adopting legal international frameworks under the International Conference, Quartet, and other, and employing the international pressure to satisfy some of the rights of Palestinian peoples and using other militant tools that don't violate international law to resist occupation. The speakers with us on the first session are Sahar Francis, the director of Addameer Association and lawyer, and the prominent member in the global movement for defending children, Palestine branch. And she's also a member in the agriculture committees in Palestine. Welcome. She will talk about mechanisms, chances, challenges of internationalization of prisoners' case in the context of international law and international community. The second speaker with us, Dr. Munir Nuseibah, a member of the trustee board in the Law for Palestine, assistant professor at Al-Quds University, and co-founder and director of Legal Clinic in the university, has a PhD from Westminster University in London, and a policy consultant in Al-Shabaka. Attendees and guests, we will dedicate a specific time for discussion, answering questions, and giving questions. We will start with the first speaker, Sahar. Please, the floor is yours for 12 minutes. Good morning. Thank you very much for this invitation to participate in this important conference. I'm honored to be a speaker in this conference. As you said, I will focus on prisoners and political prisoners in Palestine. Of course, the occupation state from the beginning of the occupation in 1967 employed and used detention as a tool to control the Palestinian community, and evolved the military orders and the military system and a whole system of courts, decisions and proceedings to keep the control over the Palestinian people and criminalize all acts, militant acts and resistance against the occupation, and also to criminalize a lot of activities, civil activities that are allowed according to international law but listed as crimes according to the definitions of the occupation state and the military system of military court system. We are in Addameer Association in our daily working with prisoners in civil and military courts in the occupation state through the monitoring, tracking and documenting of human rights violations that are targeted towards prisoners. We can say that this system that are developed by the occupation state is far from justice and the values of justice and fair trials guarantees according to international law. And for this, we say that it's time to fight and resist against the military courts and the system that is imposed by military courts through non-conventional and non-traditional tools. The appearance of detainees before these courts is not fruitful and would not arrive at the goal that we want to arrive at, which is the ending of the occupation. To be able to speak more about what we have to do, we should first survey the system, how it evolved, and what are the crimes, the principal crimes that we can refer to through the application of the system of military courts. Of course, the occupation state, instead of respecting Geneva Convention, specifically the 4th Geneva Convention about prisoners, civilian prisoners, I have to stress that most of the prisoners in Palestine are listed and covered by the 4th Geneva Convention and not the 3rd Geneva Convention related to prisoners of war. There's also the Hague Convention of 1907, which is defining what's legitimate for the occupation state about the legalization and the establishment of courts. The occupation state did not respect these treaties and started to legitimize and give laws, enact laws through the military governor, which is the executive and real governor of the occupied states. There are now 1,800 decision orders that regulate everything about the daily life aspects of Palestinians regarding moving, education, building houses, leaving the occupied land and entering again, cultural aspects, education, even granting professional licenses for lawyers or doctors, medical doctors. They intervened in all the aspects of daily life for Palestinians. And according to these military orders, they announced and designated all Palestinian parties as illegitimate. They criminalized all labor unions and all student movements and civil society organizations. They targeted Addameer Association and the colleagues in the other 5 associations targeted women committees, agriculture committees, Al-Haq Union of Agriculture Work Committees, Bisan Center for Research, and the other. Since 67, and because of the pressure, they worked towards the developing the proceedings in Israel to adopt the fair trial guarantees as they claimed. But in the core of our daily life work, we can say that these procedures that were developed by military courts are relying and based on the criminal code of Israel, and in a selective way. Military courts selected the proceedings that helped them impose more control, and they did not respect core and vital guarantees in international law to provide protection. Specifically about the persecution of children, the problem is not only with the definition of a child and the age up until 16, but also with the standards how to deal with children during the trial itself. What is considered evidence? What are the defenses that children can use during these trials? There are many details that I cannot mention all and shed light on about the proceedings. What we should focus on is that the violations don't respect, the military courts don't respect the fact that the law should be implemented only in the occupied lands. Unfortunately, the occupation state are implemented these laws and proceedings outside the territory of the occupied territory, outside the occupied lands, and this what allowed military courts to persecute activists, Palestinian international activists, for acts they committed outside the occupied states. 3 or 4 years ago, a Belgian guy, a Palestinian guy who had a Belgian passport, were persecuted in Israel for acts he had done in Belgium, and he was arrested for several months in a military trial. Also, the definitions of crimes is really problematic. As we said, there are many civil and political rights that are defined as crimes in military courts. There are also trials and persecutions for driving offenses and other crimes that are not considered from the international law perspective as within the jurisdiction of criminal courts. Entering the occupied lands without authorization is another crime that many hundreds of workers are persecuted for on an annual basis. This means that the military courts are not covering only grave crimes, which they are entitled to persecute under international law. How we can deal with all these violations? We should focus that the military system in Israel put the detainee from the outset of the detention, when violence and torture starts, through the investigation, through torture and proceedings, all this process put the prisoner under oppressive conditions to force the prisoner to reach a deal with the persecutor to guarantee the least amount of time in the final judgment. More than 99% of the files end with such deals without looking into the allegations before the courts. All the associations, Al-Asir Club, the Independent Commission, Addameer, and all other institutions who are looking into prisoners' cases, we take advantage of the mechanisms, international mechanisms within Human Rights Council and the Convention Against Torture, Children's Rights, and all the other conventions and treaties that allow for reports or individual complaints. But unfortunately, these complaints or reports stay in the field of documentation, because as we know, there are no mechanisms to force Israel to respect the obligations through these or by these standards. These organizations also submitted reports and cases to the ICC when it started the pre-trial chamber investigation and the examination of the situation in Palestine, occupied Palestine. But unfortunately, up until the moment, there is no clear decision by the prosecutor to open an investigation related to prisoners. And we say that there are 4 crimes that are listed practically within the framework of the ICC: torture, the arbitrary detention through the employment of administrative arbitrary in a very wide sense, the forced transfer of prisoners to prisons in the occupied to the occupied lands, and the also the other crimes that are part of the war crimes and crimes against humanity. We stress that the prosecutor should open an investigation and open the file of prisoners' cases and look carefully into these systematic violations that amount to war crimes against humanity and war crimes. There's also a possibility to take advantage of the universal jurisdiction related to war crimes and crimes against humanity. But unfortunately, when some organizations and institutions tried, among them the Center of Human Rights in Gaza, when they tried to file a lawsuit in Spain, the Spanish government actually amended the procedures and closed the door because of political pressure, closed the door before all Palestinian complaints. This happened also in UK and Belgium and other countries. This leads me to the most important conclusion, which is the impossibility of imposing international standards and using legal international standards without having a real political will from the Palestinian side first, to pressure these states and to exercise the sovereignty and the diplomacy to pressure these states to open the doors for lawsuits and persecutions, especially about torture, arbitrary detention, and crimes of not providing fair trials, because all these countries, as signatories in the 4th Geneva Convention, are obliged to prevent war crimes and prosecute war criminals. These states and countries also are obliged to satisfy their obligations according to international law. The responsibility is not only on ICC. I believe that Palestine as a state should look into the jurisdiction according to the signature of international treaties. This allow and make space for the Palestinian state to amend the domestic laws to enable them to prosecute war criminals domestically as well. In this case, we should talk about real political will to impose these standards, to have a real deterrence and obligation on the Israeli and occupation state to respect the rights of prisoners. I conclude with this, and I believe there will be a space for further discussion later. Thank you very much. Thank you, Sahar. Thank you for this informative information. Thank you for respecting your time as well. The second speaker is Dr. Munir Nuseibah to talk about mechanisms, chances, and challenges of the internationalization of Jerusalem case in the international context and international community. Thank you very much, Dr. Ahmed. It's a pleasure for me to be with you in this session. And of course, I'm very much pleased to be with the defender, great and amazing defender of human rights, and our friend Sahar Francis. I also thank the conveners of this conference for the great efforts to make this successful. As you said, Dr. Ahmed, I will be talking about the internationalization of the Jerusalem from a human rights perspective. I will start with saying that we are disappointed as people, inhabitants of Jerusalem and Palestinians, because of the fact that the occupation state are not respecting the different resolutions issued by the UN and other organizations to stop their violations. We see on a daily basis forced displacement, building of settlements in Jerusalem and other country towns. We say torture and collective punishment and attacks on all sacred places and repression of civil works and many other systematic violations. This makes us frustrated because these violations are systematic and they continued since 48, and still nonetheless my words and my speech were not about frustration but about what we can do regarding this. I will start first by talking on the fact that Jerusalem as a city in international law has a special position. The international community in its majority still don't recognize the international community does not recognize Jerusalem as a capital for Israel. In its two parts, it's still recognized as occupied in its west and east. I give as an example the Security Council 487 decision in 87, when the Security Council said that all the procedures and legislations that are taken by the occupation state, which it changed the appearance of the Jerusalem, especially the last code, are all null and valid, null and void in English. This means that all efforts by the Israeli state of land confiscation, forced displacement, all are not recognized by international law as legitimate. This should force us to remember that in the day of the liberation of Palestine from an apartheid, we will have to restore the situation as it was in the beginning, as if Israel had not committed all these violations. It's important that we remember that the international community does not recognize the Israeli sovereignty over Jerusalem. The international community considers Jerusalem as occupied, and as a result, there is no sovereignty over Jerusalem. This leads us and led us through the recent years as civil society and as other circles related to the UN, connected with the UN, that we make all the possible efforts to document the Israeli violations on a daily basis, taking advantage of these documentations through the UN and other institutions to attract and push forward for new resolutions that would condemn and highlight the non-recognition of such decisions. This is the general framework that is related to Jerusalem and the West Bank and Gaza Strip. We have believed that the framework of humanitarian international law, which is the framework that is related to the occupation, military occupation. So our efforts focused on violations within this framework. Maybe among the most important legal efforts that we achieved as Palestinians, which is having the advisory opinion of the International Court of Justice in 2004, which confirmed that Palestine is occupied and that the wall which divided Jerusalem and the West Bank and split it from the other regions, that it's illegitimate. This judgment was very important, but unfortunately this judgment, this advisory opinion, and all the other resolutions from the General Assembly, the Human Rights Council, were not fruitful and did not succeed in providing guarantees and helping us to take our rights. In 2017, 2018, Trump's decision to recognize the sovereignty of Israel over Jerusalem and transferring of the embassy in violation of international law and previous Security Council decisions. This decision has encouraged the occupation state to violate international law more drastically and stop respecting and paying heed to what others say, because if the states say what Israel is doing is legitimate, it doesn't matter what the rest are saying. We have witnessed a lot of efforts to highlight and confirm the Israelization of Jerusalem as declaring settlements in and putting a lot of efforts on and budget on the educational efforts as well. This is of high concern, but one of the things that make us optimistic is the efforts of the inhabitants of Jerusalem who are isolated from the West Bank, almost completely. The inhabitants of West Bank cannot easily visit Jerusalem unless they get authorization. That's really difficult to be obtained. But those who would be able to get to Jerusalem express their resistance as inhabitants. And this was prominent in the media. I will give two examples. The first example is the mosque of Al-Aqsa and the 2017 efforts to fight the electronic gates as an effort to change the status quo. I would also talk about the uprising of Sheikh al-Jarrah this year, which resonated and echoed around the world and shed light on the Palestinian question. We will not forget that there is civil society work, whether in Jerusalem or in the West Bank and Gaza Strip, and also the institutions in the 48 regions that are working persistently to focus on Jerusalem. In the few minutes that I still have, I will talk about promising activities that I believe are important to defend Jerusalem specifically and Palestine in general. The first is focusing, and the shift we are witnessing these days on the human rights arena internationally and domestically, which is focusing on the framework of apartheid. I talked about the framework of the international humanitarian law before in my comments here. But the shift we are witnessing nowadays is the shift. We are no longer talking about the international humanitarian law alone, but in details about a specific crime that is defined in international law, which is the apartheid crime. This crime it does not mean that racial discrimination. Palestinians were afraid for years from this framework because they believed that if we start talking about racial discrimination, the answer will be equality. So how we can ask for an equality between a settler and a Palestinian? No, this is not what is covered by the apartheid framework. The apartheid framework, that is according to which a state is supporting a systematic repression of a specific racial group to enable another racial group to dominate over and control, impose control over the other first group. This framework is recognized more and more recently. We have witnessed recently what many Palestinian organizations use this framework, and also recently Israeli institutions, B'Tselem and Ishlim, and also international institutions like Human Rights Watch, and we expect more institutions that will use this framework. Recently, we observed that Michael Link, the special rapporteur that will talk today, issued a call for Palestinian organizations because he intends to write a specific report about this topic. I hope that using this framework will be important for Jerusalem specifically and for the Palestinian question. All violations that I started my speech with talking about are helping the domination of a specific racial group over another racial group. These first frameworks don't delete this new framework, but they work in parallel. Another topic that I find it promising, and there are a lot of efforts on this, which is the decision of the pre-trial chamber of the ICC that was issued in the beginning of 2021, February, that recognized that Palestine is a state that is party in the Rome Statute, that is establishing the court, and said that the land of Palestine extends to the West Bank, including the Eastern Jerusalem and the Gaza Strip. So we know that the ICC today has jurisdiction over Eastern Jerusalem. And we know also that a lot of organizations provide the ICC with information. So I'm optimistic and I'm hopeful that this will be followed by significant advances. I will stop because my time is over, and maybe I will add more if I get asked. Thank you very much. Thank you very much, Doctor, for these enriching information and for respecting the time. We have 7 questions, and we will divide them between you and Sahar. The first question to lawyer Sahar about the advances made before the ICC. Maybe you talked a little bit about the topic, but the person asking needs more about the ICC and the advances done before the ICC regarding Palestine. This is the first question to you. The second question is about civil society organizations? Are there pieces of evidence for their relationship with terrorism?
The third question for Sahar. Does Israel depend on the provisions of Geneva Convention to arrest civilians, especially the fifth provisions in the Fourth Geneva Convention, which gives the right to arrest a civilian when the occupying power suspects them being involved in act against its security? The question to Mr. Munir are as follows. First, what is the probability that the case of the Palestinian refugee return will be presented among the other cases that Palestinian will submit to the ICC? The second question to Dr. Munir, is there any lawful tools that enable the international human rights organization to defend the rights of Palestinians in case the Palestinian government did not present the cases of international law that the international law violation to ICC? Are the legal mechanics effective in this frame or not? The third question to Dr. Munir, what are the real benefit to the international law in light of Israeli violations to the all international decisions and in light of the veto to UN 5 countries? Also, in light of the normalization prompt that Israel do with Arab countries, and do you still believe as a teacher with the effectiveness of international law regarding the Palestinian case? The last question to Dr. Munir. Unfortunately, there is no real to UN human rights organization in doing its rule. I think this question is for Mr. Sahar. If you don't mind, Dr. Munir, Mr. Sahar will answer this question since it regards the prisoners. The questioner says the last question says, unfortunately, there is no real rule to a human rights organization in doing its rule in protecting the Palestinian prisoner rights. So the question is, what is the legal viewpoint regarding Palestinian prisoner Israel, and what are the guarantees required under international law to protect their rights? What is the responsibility of Israel and the international community? We will start with Mr. Rahal, and hopefully you can answer each question within 2 minutes. Please, Ms. Har. Thank you. Regarding the ICC, there is Palestinian organization like الزملاء في مؤسسة الحق، المركز الفلسطيني حقوق الإنسان، الميزان and الضمير في غزة. All of those are close to the ICC work in regard to identifying the crimes in Gaza war in 2014 and the settlement issues. But practically, we can say that an investigation has started and there is files that are being submitted, and the prosecutor office staff are interviewing this organization and individual from the official Palestinian side. But I think that Israel will prevent an international investigation team, whether it was from UN or any other sides. I don't think that they will allow the prosecutor staff from ICC to visit the occupied land and start. And this raises the importance of the Human Rights Institute informations. And this is one of the reasons that Israel have announced that the 6 institutions are terrorist organization. As I have mentioned, Al-Haq Institute, Addameer والحركة العالمية to protect children have provided several files to ICC, and we try to keep this case as a priority. And I think, especially Al-Haq institutions, that the main reasons of categorizing it as terrorist organization, especially from Israeli Minister of Security Gantz, was the work of it in front of the ICC especially that he knows that one of the main accused in Gaza war and the war crimes that were being committed there. Such the answer to the second questions regarding institute organization categorizations. There are no evidence, and practically the file that was done by the various ministers that was submitted to the UN in May to convince the UN that this organization are terrorist organization and the funding should be cut off have not convinced them, cannot convince the UN, and no action was taken. From here, escalation start with the use of Terrorism Prevention Act of 2016 and the military order that consider these institutes to be outside the law. As such, we continue the move to pressure Israel to withdraw these decisions. We think that there are no legal bases, and depending on a secret file represent a fundamental damage to the effective defense a process to our right as institutions and organization, especially in regard to the Palestinian law, as we are a licensed organization in the relevant ministries. As I have mentioned, Israel does not abide by Geneva Convention. They say that they have the right to arrest civilians under international law, but they depend on military laws, military orders, and Israeli civil laws, sometimes to the Jordanian and Ottoman laws in regard to land cases. But in regard to prisoners, emergency systems, military law, Jordanian criminal law, and Israeli criminal law are what create the case in military courts. And by military law, Israel can arrest every Palestinian if they suspect him committing anything that affects security. The international law have confirmed in the fourth Geneva Convention that only the most serious crimes against the occupation power, but Israel have arrested every students, and every student activity arrest every politician for his belonging to any Palestinian organization, every journalist, every social activist that write any news on social medias, as they regard it as incites to violence, and the writer should be punished. The last questions regarding legal situation, I think we should not lose hope in international law. Even if now we don't see direct results or real result for it, that should not prevent us in high work, because documentation is important. Documenting the fact that we tried using these tools, but the door were closed in the face of Palestinian history, Palestinians. Because history will someday give Palestinian case justice with regard to responsibility in war crimes and the humanities. Maybe in the future, there will be chances. There will be a chance that's why we need to prepare files with all details and evidence that proves the credibility of our work and our crimes about the war and the humanitarian crimes that are being done to the prisoners and others. Thank you, Mrs. Sahar. I will leave the question to Dr. Munir. Regarding the first question that I was being asked about the possibility of the Palestinian case going back to light, I should say, I'll explain that first, that this court is an international crime court, which means that the trial are against people in a special geographical place about crime that they have done during a specific time. The geographic frame that we talk about is the West Bank, including Gaza and Jerusalem, which was proved by the ICC in starting this here, and the duration that was being talked about starts 13th of Huzayran 2014, as it was asked by Israel when they joined this trial. And so we speak about individuals that have done crimes. Maybe these people are political, a high-grade political, maybe part of the government, maybe a minister, a war minister, and maybe an internal affairs minister, a military man, etc., a soldier, maybe. But of course, they will not go after soldier, because as we know from the court, they only go after the heads and will make trial for them against their crimes. But does this really have any effect on going of the refugee going back to their homes? Then no, there are no real effect on that. But we have to know that compulsory moving for the refugee is a crime, and there are two parts of this crime. The first one is the crime of compulsory moving, a civilian moving from his home to and giving another person to this home. And the other crime is moving someone outside of home. So we are talking about two crimes, which need to be condemned. And I hope that this crime will be condemned. To affirm for the international community to affirm this crime, which caused النزوح and اللجوء in 1848, and the continuous moving that happens right now. But is there a direct effect? Then no. Regarding the second and third question, which are regarding the same frame, does the international law and how much do we believe in this law? Then I say regarding this question that the international law doesn't really have any teeth. I teach the international law in Al-Quds University, and unfortunately, I always start by explaining to students and colleagues that the international court don't really have any real teeth, which meaning that there are no in the international community. He can't compel the countries that breached the international law and done a crime to stop doing that, which led to the depression that I have started to speak with. But I want to add my voice to Mr. Sahar's voice by saying that should not stop us from working in the frame of international law. It's an important frame. It's an justice frame as being approved internationally. It's a shared language with all countries. We talk and they understand, which lead us to speak internationally with a shared language that everyone understands and not only a local language. But we have also to add, as Mr. Sahar has said, that we believe and we know that the apartheid that happened and occupation will not always be there, and we have to believe that, or else we can't really keep living in our house in Palestine if we don't believe in that. And we believe in justice. And I think that some days we'll have our freedom, and in that day we need every document, every record that was written by an activist, whether it was a Palestinian organization, international organization, or UN organization. We need this archive to turn everything back to how it was. Because there's a cause called the moving justice, and this subject gives me a high hope because I have read a lot about organized countries that was under occupations, a dictatorial rule, and other type of injustice. And I have saw how things have changed. Maybe they did not really expect that, that they will not free, but all these things have changed. Things changed. And when things change, these communities, these nations have started by uncovering the truth, by recovering, by showing the victims, and put all the criminals in trials, fixing law. That thing will do in some days. That's why we need to documentations to prove to prove uh, the injustice of things that was done, and that's why I believe maybe I have put all my work regarding human rights and international law because I believe that this day will come. But we should not only hope with international law, with knowledge that this is very important, whether right now, because we should not leave Israelis violate our rights while we are silent. So that's move. We should move always act, but at the same times we should act uh, political act that always happening that will lead us to freedom. Working in human rights and international law, working only in this is not really enough. That will not free Palestine. That's what she should know. Working only international law will not free them. But we always remember that this work is very important for now and absolutely for the future. Thank you, Doctor, and I approve what you have said in the start of this talk. The first lecture in the international law, I always start with a sentence for the students so that we don't always being asked about the effect of the international law by giving us our rights. I always say to our students that we study the international law by how it should be, because if we look at reality, we'll be depressed. Uh, because what we see as Palestinian, what we see as unjust, but we should not leave it, and we should uh, keep it. We should keep every tool that can help us with taking our rights, our Palestinian rights. So there are three ending questions for both of you, but we will keep 1 minute for every question. So the first question for Mr. Basil to Dr. Munir. What's the importance of taking Palestine as part of Roma Statute in the international community, international law? The second question to Mr. Sahar, regarding categorizing our organization as terrorist organization, does this affect the organization and its worker? And third question to Mr. Sahar, regardless of the political view for countries like Spain and Belgium and their disapproval putting Israel under trial. Is this a humanitarian law or is this a legitimate act refusing put Israel under trial in the Belgic and Spain court? And please keep 1 minute as an answer for every question. Thank you. I want to start from the second question. I think that this topic, the topic regarding political articles, this is not a law, neither humanitarian. Regardless of putting the criminals under trial, this happened because there are no political will, and there are political will so that the UN does not really approve it and force them to put them under trial. Why does these countries have signed the international treaties and became part of the Fourth Geneva Convention? There are dualities in doing the international law, which is completely clear. But all these problems, as my colleague Dr. Munir have said, should not stop us from knocking at the door and try using all these tools. Of course, they are using other tools as well. Regarding the different organization like media has been like putting this organization as terrestrial or unlawful organization, mean that the occupied country can enter this building and close them practically, like what happened in the Al-Arab Al-Sahi organization and agriculture union. They can put the staff management under prison. They can close all bank accounts. They can do all. They can do everything they can in the Israeli law and the military orders. Thank you, Mr. Sahar. Dr. Munir, a question for you regarding the importance of putting Israel as a part of Rome Statute, and in 1 minute. This have a great importance. From one side, putting the Palestine being part of the Rome Statute have confirmed it being a country, which have a big discussion in the international law, but maybe there are some benefit for it being as part. But in addition to that, Palestine being a part of Rome Statute is the chance for Palestine being there for the ICC being in the Palestine occupied land, juristic chance, and maybe we hope that there will be a trial for the war criminal. The criminal had done war crimes and humanitarian crimes, which is a lot. To being put under trial, and not just Mr. but also some security is being formed. Mr. Sahar, not Mr. Sahar, the start of the session has been mentioned. Well, when Fatah bin Suda have said the lawyer that move emptying the Khan Ahmar is a war crime, so Netanyahu have decided to stop it till this day. So he have stopped a little. Maybe he had not really stopped the war crime, but he at least stopped a little from doing one crime, at least, which give us some hope. Thank you, Dr. Munir and Ms. Sahar, with all the information that you have given us. Talking about this subject have may took a lot of time because it's have a lot of importance. And by answering these questions, we end this session. We thank everyone that have attended, and I will leave the mic for Ms. Muna. Thank you, Ms. Muna.